Okay, well, good afternoon, everyone, and welcome to Law 2022 Online, Family Law Shape the Debate, sponsored by our Family Wizard, with me, James Evans, Safta Mahmood, and Alyssa Da Costa-Waldman. In this live session, you can put your questions to Alyssa and Safta and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within the next few days, so please do keep an eye out for this. My name is James Evans. As I mentioned, I am a professional liaison at Our Family Wizard and the UK representative for the programme. Having spent 4 years as a teacher, I joined Our Family Wizard about 3 years ago, working with family law practitioners all across the country. I work with courts, CAS, chambers, firms, organisations, charities, all different organisations to help parents with their communication. I'm a member of the East Sussex Resolution Committee, the Family Dispute Solutions Group, along with Alyssa, and the Family Law Language Project, and I've partnered with a number of different organisations and groups all around the UK. I was also shortlisted for an Innovation Award in Mediation last year, and my main focus is to deliver training on Our Family Wizard to family law practitioners every single day. Safta Mahmood. Safta has an extensive experience in both practicing and teaching family and children law for over 27 years. Safta practices predominantly in children law proceedings alongside his lecturing and legal writing. He has been a continuous member of the Law Society Children's Law Accreditation Scheme for approximately 20 years and is both an assessor and an author, having written in various legal publications, including for the Law Society. He is a highly articulate and popular speaker who has a practical and pragmatic approach to his subject. As part of Law 2022 Online, Safta's sessions include professional guardianship order development and child arrangement orders, which one is more appropriate, and child proceedings, enforcement of child arrangements and domestic abuse, key issues and developments. And our other speaker today is Alyssa Da Costa-Waldman. Alyssa is a practicing barrister at New Court Chambers in London. She specialises in financial remedy cases and is also an expert in cohabitation claims. She is a regular speaker on legal topics and an author. During her career, Alyssa has contributed to Blackstone Civil Practice, co-authored Family and Matrimonial Law, Cavendish, solely authored Everything You Wanted to Know About Practicing Family Law, Cavendish in 2004, and last year contributed the chapter on trust law in Resolution's cohabitation book. Alyssa encourages and practices non-court dispute resolution methods and is an experienced mediator, collaborative lawyer, and family law arbitrator in finance. As part of Law 2022 Online, Alyssa's session includes running a Schedule 1 Children Act case and running a Talata case. So to kick us off, we're going to start addressing some of the pre-submitted questions that have been sent to us today, starting with you, Safta, if you don't mind. So Safta, the first question for you today: what is the current Court of Appeal guidance surrounding the use of Scott schedules in cases involving controlling and coercive behaviour cases in particular?
Thank you very much indeed, James, and thank you for the introduction to both of us. Yes, so just to answer this question, and this, of course, has been a big theme since early part of 2021. In fact, there was a case of F&M, and then the most significant decision was the Court of Appeal decision in HN and others on the 30th of March last year. And the current theme at the moment is this: because of the increased awareness of and need to recognise controlling and coercive behaviour, which, as you'll appreciate, isn't something that you can pinpoint into one or two activities. It runs into weeks, months, even years sometimes. What the significant Court of Appeal guidance on this is, we should still continue doing Scott schedules, because of course those are very a necessary feature with a view to minimising the level of dispute and consideration, and obviously given limited court time and availability. But in addition to that, the problem with Scott schedules is they could actually be a barrier more than an aid, really, because if you're finding that, the judge is saying to you, look, I want you to limit these 20 years or so of controlling coercive behaviour into about 5 points, it's just impossible to do. And because of that, the current guidance is, as of 30th of March last year, is as well as your Scott schedule, you should be doing a narrative statement as well. Narrative statement which basically puts together a statement which doesn't have to be very detailed, setting out the nature of the relationship, the nature of the relationship past and present, just so the court can then, as a better idea as to what exactly is it that needs litigating on to then make sure that's in compliance with Practice Direction 12J. So that's the current thinking as it is. But what you will find is there is the Public Private Law Working Party, which are currently looking at this, headed up by Mr. Justice Cobb, and no doubt we're going to be getting an amendment to Practice Direction 12J in line with this. Thank you.
Thank you, Safta.
Can I just add to that? Yes. I think, in practical terms, I've done many cases where, not to denigrate the behaviour, but to look pragmatically at a case. And if it's involving children, has the behaviour ever affected the children? And if not, and if it is very historical, as Safta said, it can act as a barrier. When you're trying to reduce the animosity between the parties to create a better environment for child contact and parents putting themselves first as parents, not as combatants, these fact-finding missions are not particularly helpful. And I think not only a barrier, but I think they can very often be, and I'm sure Safta would agree, counterproductive.
Absolutely. Yeah, that's right. And what you'll find is as you say, sometimes these allegations can be incredibly historical. And there was a case of V back in 2015, which Lord Justice McFarlane, before he took up his presidency, handed down. One of the things he was saying is, when people raise allegations of domestic abuse, there's almost this kind of semi-automatic reaction to say, right, we've got to list it for fact-finding hearing. And everybody kind of panics and thinks, let's list it. But actually, we've got to sit back a bit sometimes and think, is this necessary? Is it needed? And like you say, it could be counterproductive.
Exactly. Yeah.
Thank you.
Thank you. That's really helpful. Alyssa, coming to you, can one schedule? Can you use Schedule 1 if maintenance is being paid via the CMS?
Yes, I'm going to come back to that. I just wanted to say, I think it would be remiss of us on today's date,
of course,
not to recognise that today is the day that non-fault divorce has come in. So I think that's great. And I feel sorry for poor old Mrs. Owens, who sort of started it off and had to wait a long time. But thanks to her, because without her, we wouldn't be, we wouldn't have this. And I think it is a good move forward. I really do. And that's all I'm going to say about it, because that's not what today is about. But I think we should at least recognise it.
I think that's a really important thing to do. And if anyone listening does have a question, pop it in the chat. If there is specifically no-fault divorce questions, I'm sure we can see what we can come up with.
Of course.
Yeah.
Given today of all days, you're very right to highlight that, Alyssa. Thank you. Coming back to the question about maintenance for CMS.
Yeah. So can you use Schedule 1 if maintenance is being paid via the CMS? And the answer to that is yes, provided that you're not asking for periodical payments under Schedule 1, because once you're getting your PPs, your periodical payments in child support from the CMS, that to an extent ousts the jurisdiction of the court in respect of periodical payments. But what we need to remember is that Schedule 1 of the Children Act can provide so much more than simply periodical payments. So we're talking about lump sums, we're talking about settlements of property. So if what you're looking for is a capital settlement, then the fact that you've got, I would say, more of an income settlement in relation to see it from the CMS does not prevent you applying under Schedule 1 for capital.
And is the applicant limited to one lump sum?
Not at all. No. Not at all. It's not. There's a lot of confusion, I think, between what you can do under the Matrimonial Causes Act as a spouse and what you can do for children. And quite rightly, in enabling and permitting, obviously, in the right circumstances, more than one lump sum for children, there's recognition in the Children Act that children are children for 18 years of their lives, and that over that period of 18 years, their needs and their requirements will change, so that what you needed as a lump sum perhaps for the new baby and all the new baby's requirements are going to be quite different when child might need a lump sum to buy a computer and various other devices for their GCSEs some years later.
That's really
helpful. Alyssa, can I just throw in a kind of supplementary on that, which is sometimes we'll have kind of questions where, client may say to me, I'm thinking of using Schedule 1. I want to try and get property order. So you want to get property transfer, for example. But what they're then saying is, the problem with that is, because the case law seems to suggest that it reverts back into, say, joint names once the child attains majority. How would a judge view it is if I was to ask for a capital sum of, say, X £100,000, so that I've got that and I can use that to buy a house?
Yeah. First thing is, you said it reverts back to joint names. If it won't, it reverts to the payer upon the child's majority. So that's often a problem. What we tend to see, and you will know this very well because you do a lot of Talata stuff too, is that firstly, the Schedule 1 application in relation to property is often tagged on to a Talata claim, because the claimant, who's often the non-owning party in the Talata claim, wants to wait and see whether they're going to be successful, and if so, what they get. And if what they get from a successful Talata claim is insufficient to rehouse themselves and the child, they can then make an additional claim, or have already made a claim that is stayed pending that outcome under Schedule 1 of the Children Act. And the difficulty is that you can have a situation where, if you are that claimant stroke applicant, you get your rightful share that's yours and you keep that, and then you get another bit to add to it that you don't keep if you're successful in the Schedule 1, that reverts on the child's majority. And then that person is in a difficult position. They may well have to sell their home to pay back the child element of that lump sum. So in many ways, and there's no reason why one couldn't, under Schedule 1, say, I don't want property from you because I'll have to give it back. What I like is a lump sum for the child's housing needs. I've seen it done. It has been done.
Absolutely. Yeah.
So thank you for raising that. Good question.
Yeah, it was. Thank you, Safta, and thank you very much, Alyssa. Of course, we've got the changes coming in with no fault divorce today, but there were some changes last year, Safta, particularly to the Domestic Abuse Act from last year. So can you give us an update on there? What's the definition of the domestic abuse in light of that new act?
Sure, yes. So the Act, it got roller sent almost a year ago, actually, 29th of April last year. And the definition of domestic abuse, most of it is across most legislation that came in on the 1st of October last year. But the definition, putting it simply, is this. It's where you've got behaviour from A to B, where the two of them need to be 16 or over. They need to be what's called personally connected, and the behaviour has to be abusive in nature. So essentially A to B, 16 or over, personally connected, and abusive in nature. And it's interesting, the abusive in nature is the one that I think many people have kind of latched on here, because it's incorporated not just the previous existing definitions of abuse as we knew, i.e. violence, sexual abuse, matters related to coercive controlling behaviour, culturally specific forms of abuse, but it specifically brought in economic abuse. Now, I know some people took the view that we already kind of had that within controlling and coercive, and I suppose there is an element of it, but to bring it in as a separate type of abuse itself, I think is fantastic. And as you can imagine, so many of our cases, both in terms of, some of the Talata cases, the financial remedy cases, the children cases, so many of these involve financial abuse in its various shapes and forms. So, I'm very much pleased that that particular provision has been brought in.
Yeah, that's great to hear. And I suppose go on.
Sorry, James. I've got a burning question for Safta. So you said, as part of the definition, you have to be over 16 and personally connected. Now, I recall in the 1996 Family Law Act, so I've got two questions, really. What's the relationship between that and the new Domestic Abuse Act? And secondly, is there an overlap or is there a difference between personally connected and associated persons?
Very good, very good. And thank you for that, Alyssa. Very good question. Well, that's one of my gripes at the moment, because what the 2020 Act should have done, and I think the intention behind the bill and the Act, was to replace the definition of associated persons, but with this new personally connected definition. Just before I kind of answer that one, there is a difference between them in the sense that one obvious one is you're personally connected if, for example, you are or have been in an intimate personal relationship with each other. So that's your kind of boyfriend, girlfriend, maybe, who don't live together, they're not cohabiting, and they maybe see each other, at different times. That's their personally connected definition. But the associated persons definition under Section 62 of the 96 Act also says somebody who is or has been in an intimate personal relationship, but then it uses the words of significant duration. Now they've actually dropped that from the definition of personally connected. And I've had a number of cases where we've had to argue to say, well, look, what is significant duration?
What does it mean?
Yeah, I mean, I've had care cases, for example, where my view has been, somebody's together for a week or two, arguably, if there's a baby on the way, is it significant?
It could be significant because they're having a baby. It could have been a one-night stand.
Exactly. Exactly. And that's where the personally connected has dropped the significant duration, but Section 62 still retains it. But what the 2021 Act has not done, and I don't know if this is just an oversight on the part of the drafting, is it hasn't specifically said that the 96 Act definition is to be repealed and replaced by this one. So actually the two of them stand alongside each other at the moment, and because of that, I think we're bound to have some interesting interpretations going forward.
I agree. And I think it's a big mistake that we've got a new act without the repealing of the old one. And I just think it's such a shame. I actually did an article recently, November, in legal terms, I think that's recent, on economic abuse. And I did highlight that problem.
Yes.
Is it this one? Is it that one? How do you know which one to use? And there's no answers to that right now.
There isn't. And I know, Alyssa, you kindly mentioned the new divorce law. And in fact, just to kind of mention that's exactly what's happening with the new Divorce Dissolution and Separation Act. Because rather than having an entire act in its own right, what they've actually done is they've amended the MCA of 1973. So for somebody who's kind of moving into divorce law, they're having to get these two acts and read them alongside each other, which is a real shame again. It would have been nice to have the one, replacing the other. So there we are.
I mean, I would presume that with all these new acts, it would come with a complicated mesh of sort of different orders that you could put together, right? So in that situation, can both a care orders and a special guardianship order coexist? Is that common?
Very good. It's not very common at all. But interestingly, last year there was a case just on this, and it's a very unusual situation. It's where the case that I'm thinking of, some of you will have seen. It's the F&G case that I have mentioned in the notes for you. And it is possible, if you look at kind of Section 91 of the Children Act, the two can coexist, a care order and an SG order. And in that particular case, it was a little bit of a moot point, which is that again maybe a mistake on a part of drafting? Should, when an SG order is made, should it actually be replacing a care order? Because the net effect is a care order gives local authority, amongst other people, parental responsibility. They then decide on placement. SG order gives you this elevated parental responsibility. Even the word elevated is somewhat controversial. The word special, what does special actually mean? Which is, but it gives you this kind of elevated, parental responsibility. How can you have a care order where a child is saying foster care, but then you retain as a special your parental responsibility under special guardianship? And anyway, this case of F&G, what it did, and I can see the thinking behind it, is the man involved here, he was the former stepfather of the children. He'd brought up as a stepdad these children who were twins, age 10, from when they were born to 10 years of age. He sadly couldn't meet their needs any longer. Local authority stepped in, got a care order, placed these kids in foster care. But to maintain his involvement, his significant involvement with these children, obviously that connection's huge, isn't it? It's massive. To maintain that, they allowed him to keep his SG order. Not because he was going to be providing care for them, but more to recognise that level of involvement. So it's unusual, but possible. And that's where, as James is saying, sometimes I think it's deliberate drafting on the part of Parliament in doing that. And I think in this case it was deliberate. But as Alyssa has already mentioned, I think problem is with, for example, associated persons and personally connected. Was that deliberate, or is that an oversight? And I think only time will tell.
So if there is a care order in place, and if there is a need to test the placement of having the child live with the prospective special guardian for a period of time before deciding on recommending a special guardianship order, is there a need to extend the care proceedings in that situation?
Yes. Thank you for that, James. That's been sadly a massive area of debate, and the leading authorities, the PS case of 2018, the Court of Appeal decision. The simple answer to that is no. There is no need to have the child in placement in order to then decide whether or not the special guardianship order should be made. But having said that, if based on the facts of the case, it's felt that actually we do want to test the placement, because as you can imagine, being assessed in theory without the child being placed with you, it's a very different, kettle of fish to having a child placed with you. And therefore, what the law says on this is, if you need to test, even though the law doesn't require it, but if you feel you need to, but you're close to the expiry of the 26 weeks, which is when we have to be looking to conclude these care cases insofar as it's reasonably practicable, then the only way to deal with that is to extend the proceedings. What you shouldn't do is to conclude on a care order and then expect somebody to apply for discharge, because as you can imagine, the whole funding issue changes and people are struggling to get lawyers and so forth. It's best to keep it in place and then come back. So that's the current thinking.
That's really useful guidance, Safta. Thank you. Alyssa, coming to you next, there's a couple of questions that have come through regarding property. And one of the questions is, does my client have a claim if their name is on the title, but they've never lived in the disputed property?
Yes. Yes. Lots of people think in a Talata claim, you have to have lived in the property. Absolutely not. There are some interesting cases of, what shall I call it, abandonment. And practitioners will be familiar with Jones and Kernot, where eventually that was divided 90% to the woman and 10% to the man, because he had left some years before. And because we now look at whole course of conduct, the fact that he'd never paid a shred of maintenance for his children also went into the mix. So he had his name on the title and he didn't get half, because the court looked at how they'd conducted themselves financially. There was another case, Quaintance and Tandon, where the defendant had actually left the property, lived in it. They weren't quite sure whether it was 3, 4, 5 or 6 weeks, but he hadn't lived in it for very long. And he didn't get anything because it was said he had completely abandoned it. But there are cases where somebody could still be liable on the mortgage, whether or not they're actually paying it, has their name on the title, but has never, for various reasons, not lived in the property. But it's whether your name is on the title or it's not, but you're claiming a beneficial interest for whatever reason. But even if your name is on the title and you've never lived there, that is not a bar to making a claim under Talata.
Interesting. So if the property is in joint names, are the contributors then relevant?
Contributions are only relevant if you don't have a conclusive TR1. And what we need to remember is that, the old case for Goodman and Gallant said the documents of title are conclusive. So as long as the little box is ticked on the TR1, or one of the boxes is ticked, even if the box is not ticked, but the registration at the land registry is clear as to the ownership and the TR1 is signed, that's also conclusive. So provided the documents of title are conclusive, that's usually the end of the matter and you can't argue contributions. There are people that try, but as we know from Pankania and Chandegra, that's a bit of a waste of time. Don't do it.
That's really helpful, Alyssa. Thank you.
Alyssa, so I was just going to, just as a little supplementary on that, if I may, because I know sometimes we'll have situations where, say, you've got the so-called, bank of mum and dad, where absolutely, they're an unmarried couple, young couple, they want to buy their first property, and say the lady's parents are saying, okay, look, here you are, we're going to help you on the property ladder. There's 20 grand for you to pay towards a deposit. And there they go, to obtain the mortgage. The building society want the parents to sign, the grandparents to sign it over as a gift. But between the four of them, the grandparents, their daughter, and their
son-in-law, may not be grandparents at this point.
May not be grandparents, of course. It could be others, absolutely. Between the four of them, they say, oh, look, I know we signed that as a gift, but between the four of us, if you guys ever do split, there is that understanding, isn't there, that you're going to give us the money back?
Oh, my God.
20 years later. Absolutely.
A number of times, I'm dealing with cases where it is the bank of mum and dad.
Yeah.
And they say, well, we didn't do it. We didn't put anything in writing because, hey, we're family. So all I would advise is where parents or indeed anybody else is making a contribution to the purchase of property that is essentially the home of others, they should consider what they are, why and what they're giving the money for, the basis upon which they're giving it. Is it a straightforward gift? If it is, have a deed of gift. And I've got an interesting war story about that. Have a deed of gift. If it is a loan, set up a proper loan agreement. If it's an investment such that the parents or whomever is sort of buying an interest in the property that they then recoup proportionally when the property is sold at a later stage, they need to say so, because if the parties to whom the money is provided, notice my use of the word provided, get married, then the parents can often end up being interveners on a tolata basis as a preliminary issue in the matrimonial proceedings. Otherwise, they can all end, if they're not unmarried, they can all end up either being parties, witnesses, whatever, in a tolata claim. It's so important. And I think it's down to conveyancers to investigate at that stage, where's the money coming from and on what basis. And I hate to say it, and I'm sorry if we've got any conveyancers present, but generally they don't turn up to these presentations, and they need to, because I think conveyancers are inherently lazy and they don't actually do that investigation. It's conveyancing, sadly, is a sort of conveyor belt in solicitorial life, or licensed conveyancer life. And I think that's a shame. And I think they ought to do more investigations. Very quickly, I had a case many years ago. Girl was getting married. Her father came to me and he said, I'm giving the two of them a lot of money. His wife had died. I'm giving them a lot of money to buy a flat, and then they're going to get a mortgage. And this is the basis. I said, don't, whatever you do, give it to both of them. So I did a deed of gift that I then referred to in the prenup. Right? And the deed of gift set out that it was a gift to the daughter only, that when the marriage was due to take place. And I did what we often call the liability approach. I worked out what percentage the gift of money was in relation to the price of the property that they were buying, what percentage the mortgage contribution was, and they were both 50-50 of that mortgage contribution, and the boy was putting in something like 20,000 as against the girl's 200 and something thousand. Now remember, the dad wanted to give it to both of them. 6 months after the wedding, it turned out that he was committing adultery with one of the wedding guests.
Oh dear.
The whole thing broke down.
No.
Yeah. And thankfully, she's got the flat and she paid him out because we had those documents in place. So,
if you didn't, what could have happened? What could have been the repercussions?
What could have happened? The father was prepared to give it to both of them as a gift. Oh, because he's such a lovely guy, my future son-in-law.
He would have had claim to 50% of that gift. Wow.
Yeah.
Gosh.
Yeah. And because of that, follow that through, 50% of the gift, 50% liability on the mortgage, 50% of the flat.
Yeah.
And thankfully, I said, don't do that. Just give it as a gift to her. However lovely you think he is, give it to her. And we'll document this, which we did. And of course, all of those documents then became relevant and as a schedule to the financial remedy order. Because when it all broke down, I then did a separation agreement to begin with in readiness, and we turned that into the financial remedy order, which had appended to it the deed of gift and the prenup.
Wow.
Fantastic. You managed to ring fence that. Absolutely.
Yeah, absolutely. But it just shows you, and it was a really good question, Safta, because I think, unfortunately, I was having this conversation the other day. Unfortunately, we need to get to teenagers. We need to educate teenagers. You know, they do life skills at school, don't they? But they don't go into detail about buying property with someone else and the pitfalls and where the money's coming from and what you need to do. And I'm sure, you know, we really ought to sort of try and promote that kind of education in schools, because it is a life skill. You know, how many people still ask, isn't there the concept of a common law wife? No.
Absolutely.
So what happens if they're not married? Would you recommend they sign some sort of cohabitation agreement?
Absolutely. There's no reason why you still can't have a deed of gift if they're getting money from the bank of mum and dad.
Right.
And I would certainly advise the mum and dad, you give the gift to your child, not to the child's partner.
Yes.
Right? Your child only. So you have your deed of gift, and then you have a cohabitation agreement that refers to the deed of gift and sets out everything in relation to property ownership.
That's extremely helpful, Alyssa. Thank you. And I think a very, very good example of when these situations can really benefit.
I mean, who knew that was going to go wrong?
Well, of course.
Absolutely. And of course, you know, from today, Alyssa, you mentioned in that case, the husband sadly went and committed adultery. But as from today, as you know, we won't be pleading adultery anymore with the new. We'll simply be saying that the marriage has broken down irretrievably. So you won't be giving reasons anymore as to why that is.
But presumably that will still be considered.
It shouldn't be. It shouldn't be. Although, I mean, we've got the old Miller case.
Conduct. Where's going to leave conduct?
Well, that's it. There's the old Miller case. You remember the Miller case all those years ago in 2003? Because what happened there was Mrs. Miller and Mr. Miller got married. He said to her, "Look, I'm making £1 million a year. You're just making £85,000 a year. You know, it's pocket money compared to what he was making." He said. So he said, "Look, give up work. You know, I'll look after you. Let's have a family." So of course she said, "Of course, let's do it." Tried to have a baby, sadly had a miscarriage, tried again. Third time, they didn't try because he went and had an affair, committed adultery. The Court of Appeal allowed at that stage for her to use his adultery as conduct for the purposes of Section 25(2)(g), i.e. where it would be inevitable to disregard. But the House of Lords, as it was then, said, very sorry, because it's a fact for divorce. And, you know, but now that it's gone, it'll be interesting. Are people going to bring it in?
I mean, I've often said, because if you've ever given your client the Form E to complete in draft, you often get one back that's got adultery written in red in the conduct bit. And there was an old case many years ago, and I can't remember the name of it, where a judge actually said mere adultery is not enough. It's mere adultery is not enough for conduct.
Really?
But maybe so. I'm thinking, mere adultery, like one person, that's not enough. But what if somebody went through the whole Royal Philharmonic Orchestra people, you know, each one of them? That might be more than mere adultery. But you know, when we're talking about conduct in the context of financial remedies, my view has always been, and I think the authorities support it, is that it's got to be financially related.
Yeah,
sure.
Yes.
So that's why mere adultery, sadly, to put it that way.
That's right. That's right. But I suppose people could probably, you know, if it did, I mean, I'm not in any way suggesting, you know, people should quote it, but I suppose they might think, well, you know, because he or she has committed adultery, I've gone into depression. I can't go back to work. It's affecting me in this way. So I suppose.
Or I've gone for massive retail therapy to make
Absolutely. Absolutely.
Spent all the money.
Yeah, that's right. So it will be interesting.
I suppose the flip side of that is that they could say that they were led to adultery, as in there was so much abuse going on at home, the only way out was through someone else.
Yeah, that's right. And that's why judges got to be careful.
Adultery is very much a symptom, not necessarily the cause.
Not a cause.
That's right.
Really interesting. Really interesting. Thank you both. I suppose, I mean, we touched on the finances there, and linking back into what you were talking about earlier, Safta, with the new Domestic Abuse Act. What kind of things does economic abuse cover specifically? I mean, is this linked with controlling and coercive behaviour?
Sure, yes. So I suppose it's tied in with what you said earlier. But I suppose one of the things specifically with economic abuse is the case of F&M comes to mind, the one of January last year by Mr. Justice Hayden. That's the one where this particular man, the way he abused the two women concerned, it really sickens you really sadly, because, for example, he used to give almost minimal amounts of money. You're talking about £5-10 a week for the lady to live on, and that is so significant in terms of not only the controlling coercive behavior, but of course it's a specific form of economic abuse. So controlling access to monies, access to resources, ruining parties' credit history. You could just imagine, can't you, how people can be so divisive in the way in which they cause economic abuse. So it's huge in that regard. Manipulating the benefit, getting child benefit monies and keeping it for themselves rather than spending it on the children. Those kind of things.
Yeah,
it's huge.
That's really helpful. Thank you.
Yeah, very often in the matrimonial cases, you get where they've stopped use of the credit cards, not the debit card. So and they don't know until they go and queue up in the Sainsbury's checkout.
Yeah,
and can't use the card. I had a client once whose husband used to give her the money to go shopping and required her to account for everything she spent, even if she needed something like tights or sanitary goods, stuff like that, which is really kind of goes to the core of abuse.
Absolutely.
Yeah, that's really tough. Thank you. So coming back to Schedule 1 applications, if on a Schedule 1 the applicant mother has compromised her claims with a condition included that she will not make any further applications, can the child apply under Schedule?
Well, yeah, I think there are two things here. I think whatever you do, you can never oust the jurisdiction of the court. I think that's important. And secondly, even if the mother has, in an order, appears to have compromised her claims on behalf of the child, it's always open for the child to make their own application. And of course, children are very likely, because they would not necessarily have an income, could get legal aid to make their own application. And once, and of course they can do it even if they're over 18 but training and still in education. And I once had a trainee solicitor whose father was really awful. And I'm sure this is why he got his training contract, because he'd made an application under the Children Act to get money to help him while he was in his training contract. And he took his father to court successfully under Schedule 1.
Wow.
Yeah.
Really interesting.
I did that working for a very good firm of solicitors.
Well, yeah, with that kind of action, I'm sure they did get picked up quite quickly.
Yeah, absolutely. Absolutely.
That's really helpful. Thank you. Safta, coming back to you, if a person was looking to care for their niece or nephew, what are the key differences between the exercise of PR in the case of a child arrangements order, living with, or special guardianship order and adoption?
Sure, thank you. So, there are a number of differences, and I suppose the key ones I would suggest always come down to the issue of parental responsibility in that regard. So, with adoption, of course, parental responsibility is exclusive in the sense that it is the most draconian children order you can obtain. It's obviously the right order in the right circumstances. It will promote the child's welfare, best interest, but it gives the adopters parental responsibility exclusively. So everybody else loses it. Birth mother, birth father, local authority, everybody. Special guardianship, as we said, it gives you what's called elevated parental responsibility. It allows you to exercise parental responsibility to the exclusion of all other people with parental responsibility other than another special guardian. But there are still limitations with it. For example, you can't take the child out of jurisdiction for more than 3 months. You need need permission, you can't change your surname. There are specific elements contained within the Act limiting that. Child arrangements orders, out of those three of them, I suppose, is the one which is the lesser of the three, because even though you do get parental responsibility, it doesn't allow you to exercise that, which may be incompatible with the exercise of PR by any other person in terms of an order. What I mean by that is, if, say, the person was to look after their nephew and niece, and they had a living with order, a child arrangements living with, it doesn't allow them to, for example, go and change their name or even change a child's schooling, for example. It does allow them to take the child out of jurisdiction, but there's a limit of only up to 28 days. So I suppose each of them do have varying degrees of exercise of parental responsibility. And certainly what I'm advising, I think one of the things I like to focus on is, I know money is obviously very important. SG, you get a special guardianship support allowance subject to means tested. Adoption, financial support is very limited in many cases, and special guardianship, child arrangements, very limited also. But I would say the first question people need to ask themselves is, to what extent do I want to exercise PR? And I think that helps them to know which order perhaps to go for. Okay, thank you.
Thank you, Sata. That's really helpful. Alyssa, coming back to you, how do you know whether to issue a claim under Part 8 or Part 7?
Well, the rule of thumb is usually Part 7. Let's start with Part 8, because I think that's the simpler one. Mm-hmm. When the Wolf reforms came in, which is now well over 20 years ago, so there was some edict the other day to stop calling them the new rules, because they're so not new anymore. That was one of an amended civil procedure rule. We can't call them new. When they first came in, Part 8 referred to issuing under Part 8 where there wasn't a substantial dispute of fact. Now, I don't think that form of words is in the current edition of the White Book under Part 8, but that's always what I recall as my rule of thumb. If there isn't a substantial dispute of fact, so if, for example, the parties agree they are joint legal and beneficial owners, it's definitely a 50-50, but one wants to sell and the other one doesn't, that to me would be a Part 8, because there is not a substantial dispute of fact about the ownership of the property. It's whether it should be sold now or not. But if you've got, for example, the sort of case where the disputed property is in the sole ownership of one person and the non-owning party is claiming a beneficial interest, then it's likely that there's going to be issues of assurances that were given, words that were said, promises made. Was there an agreement, arrangement, or understanding? What evidence is there of all of that? Who said what to whom when? And stuff like that, issues of detriment, whole course of conduct, dealings financially. That you can tell there's going to be a substantial dispute of fact. And if there is going to be a substantial dispute of fact, then that's when you would likely issue under Part 7. And the difference between the two is when you issue under Part 8, you don't need nasty particulars of claim that we family practitioners are not terribly keen on. You can simply support your application, your claim, with a statement, which we're all very good at doing because we love telling these stories. But if you issue under Part 7, it is a requirement that you have particulars of claim. They don't have to accompany your claim form. You can serve those 14 days later. But I would advise family practitioners who do not usually draft things like particulars of claim, either at all or with any degree of frequency. I would suggest that you get counsel to do that.
And Alyssa, can I, just as a supplemental to that, and absolutely grateful for
I love your supplemental.
Thank you. and on that one, and you're absolutely right. I think as solicitors, we run a mile when we have to draft particulars of claim and defences. So of course, we try very hard to try and bring it within Part 8 if we can. But also, of course, with Part 8, because of the difference in the fees. There's such a substantial difference in, if it's a Part 7 claim, you're talking about kind of 5% of the claim if it's more than, I think, £100,000. So if I suppose in my mind, I'm thinking, there is a substantial dispute here. You know, the house is in the bloke's name. The lady is trying to, issue for beneficial interest, constructive, proprietary estoppel, and so forth. If I was to lodge under, say, Part 8, how involved does the court get in that? Will they say, no, actually, this is wrong, we're going to...
Well, there's 2 points to that, Safta. There's 2 points. One, the defendant can dispute jurisdiction and raise that with the court. But also, the court can do it of its own motion and say, this is not properly a Part 8, it's a Part 7, and turn it all around. And very often, and you really don't want to be the defendant when the claimant has done it wrong, because I have found myself in the position of having to produce a defence to what's essentially a witness statement under Part 8, because the court has turned it into a Part 7, but for issues of proportionality and costs, declined to make the claimant draft particulars of claim.
Yes.
So that's a bit complicated and not a very pleasant task.
Yes, absolutely. And again, just maybe tying in with that, if I may, is we've got Schedule 1 of the children, of course, which is family proceedings. And then we've got Talata, which is, of course, civil. And if, say, the man lodged a Talata, lady lodges a Schedule 1, because these are two opposing applications, how do they run that? I mean,
no, they're not necessarily opposed. I mean, there might be, but from the woman's point of view, there's like, oh, great, there's a Talata. I want to win that as well when I defend it, and I'm going to issue my Schedule 1. You're quite right, because 1 is civil. Talata is very obviously civil. Schedule 1 is family, and most of our courts at this moment can't do both.
Absolutely.
Right. Yes. So you cannot consolidate two claims or a claim and an application in 2 separate jurisdictions. We know this from the case of W&W Joinder, where you conjoin them if you can. But the difficulty, I mean, Lord Justice Thorpe at the time thought it was a great idea to conjoin them. But of course, we can't do that, because rarely are you in a court that can deal with both. Now, you could be in a court where the judge can deal with both. So you'd have to, if you were in a county court or a family court, you'd have to make sure that you had a judge that had both county court jurisdiction and a family ticket. Not always the case. So there are options. What I've seen done, and I've done in many cases, and I think I mentioned it before, is where you've got the claim and the application issued in different courts, to stay one. And I think that if you were going to stay one, you would stay the Children Act pending the outcome of the Talata.
Yes.
That's probably the most sensible thing to do.
Absolutely. That's really helpful.
One would hope. And there's been talk of this for years now, that the Central Family Court should have Talata jurisdiction. And that would simplify things so much. It
would. And in fact, the president, if I'm correct, the views from the president's chambers, he was saying recently that actually that's still on the agenda, and we may eventually get Talata coming into family law at some stage. But
but when?
Exactly. Well,
everyone was saying that no fault divorce was meant to come in the 70s. So
I know.
I mean, 50 years late for that. So maybe in 50 years' time, we'll see that coming into the CFC.
Exactly.
I don't think either Safta or I will be here.
Absolutely.
I have faith that you will. I promise.
Thank you.
maybe slightly more relaxed terms.
Yeah, maybe.
Thank you.
So following that, Alyssa, you did talk about joint tenancy. How do you know whether it's appropriate to sever a joint tenancy?
The answer is you don't.
You don't.
Every case is different.
Okay.
So you would only sever the joint tenancy. That's the only thing that's really capable of severance. And the reason that you would think about severing is because you would want to avoid what sounds like this wonderful summer drink from Starbucks, the jus crescendi, the right of survivorship. So if you really hate your former partner, it's like, well, if anything happens to me, I don't want them getting this by right of survivorship if I die before we've resolved this. If somebody is terminally ill, and they want to ensure that their half goes elsewhere, not to the former partner they absolutely hate right now, that could be a reason to do it. That could be a reason. But it depends, is the home still a home for children? There's a lot to take on board. And I have to say that good old chestnut, it's every case depends on its own facts as to whether it's a good idea to sever or it isn't. The effect of severance is to get rid of the right of survivorship and to create a tenancy in common in equal shares, unless you're trying to create something else. But even then, that's not guaranteed. Even if you said without severing the joint tenancy, give you notice without prejudice to there being an equal tenancy in common in equal shares, even that's doubtful. So the best you're likely to get if you sever is a tenancy in common in equal shares, which means that the respective tenants in common can then leave their respective shares to whomever they want, and it won't automatically go to the other person. But that very much depends on all the facts of the individual case.
That's right. And thank you, Melissa. And really just following on from that, I know when I first started in the 90s, I found it was almost taken as read that when I used to see couples, it was almost taken as read. They say, yes, we'd like to sever, please. But I don't know, nowadays, I just find people are thinking, so I've had this lady, for example, she said to me, why should I sever? I think he's going to go before me, so I'm going to take the risk.
Exactly. Yeah, that's it. And that
Absolutely.
is it. So I think, as I said, if somebody is terminally ill, then there may be a reason to do it, depending on how close they are to the death and how close you are to getting the litigation resolved. I've got to say, these days, you're probably going to die first.
That's right.
Every chance.
Thank you.
Thank you both. We've got about 5 minutes left or so. So if anyone listening does have any questions they'd like to ask Alyssa or Safta, please do pop them in the chat. Now's your last chance to ask them. With our 5 minutes left, our next question we've got is for you, Safta. Does practice direction 12J create a presumption against there being any contact pending a situation where the court gives direction for a fact-finding hearing or where disputed allegations of domestic abuse are otherwise undetermined?
Okay, simple answer to that is no, it doesn't. It doesn't. If the main kind of provisions here are paragraphs 24, 25, 26. You've got some elements there, also paragraphs 14, 15, 16. What it does say, though, is this. Let's say I'm for dad. We've lodged an application for child arrangement, spending time with. Mother's raising allegations of domestic abuse. Let's assume judge puts it off then for finding a fact hearing. Now, what PD12J does say is in terms of interim child arrangements, and it specifically does use the word interim. I know some judges still take the view that it should be called child arrangements pending further order, but PD12J does mention that. It does say in terms of interim child arrangements, courts shouldn't be looking to enable that if it's going to expose the maker of those allegations or the child to what's called an unmanageable risk of harm. And that's the important terms, because that doesn't raise a presumption. But sadly, you find in some of these cases, people do latch on that. So paragraph 25, people latch on that, say, well, you can't have contact until it's been determined. What I would suggest is if you're for the applicant in that case, be father, mother, whoever the applicant may be, I would suggest you look at paragraphs 26 and 27 of the practice direction, because that does say that in the interim, the court does have to look at the benefit of contact. They do have to ask themselves, should it be supervised? Should it be supported? At the very least, can we even facilitate indirect contact? So there is an active responsibility upon the court to ask themselves the question of interim contact pending any final fact hearing.
Safta, I've got a supplemental for you.
So
supplemental to that, wouldn't it be something that would have been addressed in the initial Kafka safeguarding letter?
It should have been.
Because surely that's Kafka's job to sort of highlight, for me, there is a presumption in favour of contact, in favour of children maintaining relationships with otherwise absent parents. And therefore, it's for Kafka to say, there is this issue. However, this is how the child can be safeguarded in the interim.
Yes, that's right. I mean, certainly the safeguarding, the Schedule 2 letter is done to help the judge to know, right, what are we with any convictions, cautions, investigations, so that the judge shouldn't be making any interim order which may be adverse to what's in the child's welfare best interest during that time. But yes, part of that could be to say, well, actually, in the interim, we're of the view that there could be indirect, for example, or supervised, facilitated, as long as these safeguards are put in place. And like you say, there is that presumption of parental involvement. What that doesn't say is what amount, but it does presume that the parent is to be involved to such an extent that it furthers the child's welfare. So absolutely. Thank you. I like that supplemental. That was good.
I think the supplementals today have been fantastic. And unfortunately, that is our time, I'm afraid. I appreciate there are a number more questions that we didn't get to today. So if those questions didn't come through, our apologies. But thank you so much to Alyssa and Safta. And thank you to all of you for attending Law 2022 Online, Family Law Shape the Debate, hosted by Our Family Wizard. Thank you to Safta and Alyssa again, fantastic speakers. I'm sure I'll be seeing both of you very soon.
Thank you, Jen.
Welcome. Absolutely. I don't know when we're next seeing each other, but I'm sure it'll be sooner than we think. There's always something coming up, so thank you for that. And don't forget to join the Solicitors Group Law 2022 Online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days, so keep an eye out for that. And there is still time to watch the pre-recorded content from Safta and Alyssa. Your expiry date will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this live session, if you haven't already. The book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open to anyone for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue worth £35 plus VAT. You can also visit our exhibitor profile for more information about Our Family Wizard, and I do encourage you to do so. If you have got any more questions about Our Family Wizard, you can reach out to me anytime. Finally, feedback forms for the events will be sent out when the event closes. By completing this, you will receive your CPD certificate. Thank you again. Thank you, Alyssa. Thank you, Safta. We'll see you soon. And thank you very much. Have a lovely day.
Thank you. Bye for now.